Welcome back, ladies and gentlemen. We will now begin our lunchtime chat on the A to Z of persuasive written and oral advocacy. Mr. Warathorn Wongsawangsiri, member of YSIAC Committee and partner of Herbert Smith Freehills Thailand Limited, is the moderator. The panelists are Mr. Pisut Attakamol, Ms. Sapna Jhangiani QC, Mr. Edmund J. Kronenburg, Ms. Amanda Lees, and Mr. K. Luan Tran. A warm welcome for our moderator and speakers, please.
Hi, good afternoon, everyone. First of all, let's start with this session. So my name is Warathorn. I'm partner Herbert Smith. With great honor, I am really pleased to be moderator for this two-day lunchtime chat on topic of A to Z of persuasive written and oral advocacy. Also, I have a short time to introduce our honorable of the panelists. Go with the first one, Kun Pisut Attakamol, partner of Baker & McKenzie and co-president of YTHAC. Kun Pisut is really well-known practitioner for both arbitration and litigation in Thailand. Also, he also one of my supervisor when I was like summer clerk at Baker & McKenzie Bangkok office like 20 years ago. The next, let me introduce you Ms. Sapna Jhangiani, QC. Sapna is really recently recognized as one of like the best lawyer in Singapore for arbitration and mediation by Best Lawyer 2020. And also, next one, Mr. Edmund J. Kronenburg, FCIArb and FSIArb managing partner, Braddell LLP. Edmund has over like 22 years experience in dispute resolution. He has been recognized in several publishers, including Legal 500, Chamber, Who and Who, and so on. Many recognition. On the next one, let me introduce Ms. Amanda Lees, partner Simmons and Simmons in international commercial arbitration practice. She is really well-known practitioner and also arbitrator. She has sit as like have been appointed as an arbitrator for several institutions, including SIAC, SKIC, IAC, and so on. A long list of like experience and recognition as well. And last but not least, Mr. K. Luan Tran, partner King and Spalding. Luan has over 20 years of experience in international arbitration. He's just among few first chair trial and arbitration lawyer with like achieved US and Southeast Asian practice. He also acquisition speaker on author from Vietnam jurisdiction. For this session, we will like mainly discuss how to conduct persuasive written and oral advocacy. This will be a great opportunity for the audience to learn from one of the best in their field. So I will turn this session kind of like Q&A basis, and will address the question to each panelist. But feel free, if you have any question, you can jump in, and also our panelists will share their experience and their point. Now, let's start with the first issue about written advocacy. For the first question, the importance of written advocacy in international arbitration cannot be understated, as it presents one of the first opportunity to start persuading the tribunal of the stand of your client case, even before the hearing start. Including like the statement of claim or defense. So what are the core features of persuasive written brief? What do you think about this, Amanda? I think we go first with Amanda for this topic.
Thanks, Warathorn, and welcome this afternoon. Welcome to this lunchtime session. It's you're nearly towards the end. I'm sure you've starting to get exhausted after such a long and very comprehensive academy. Yes, as Warathorn, as you said in the introduction to this question, written advocacy in international arbitration is incredibly important. It is far more important in many ways than it is in litigation. Often in litigation, pleadings are bare bones, whereas in arbitration, your briefs need to be very comprehensive and cover both the facts as well as the law. And it's very important in terms of persuading the tribunal. Now, in terms of the initial statements that you might want that you need to file. Starting right from the beginning with the notice and the response to the notice of arbitration, I think you need to put your best case forward in those documents as well. Obviously, those documents are much briefer. There's a number of procedural elements which need to be included in those documents. So make sure you check off all of the elements which are specified in the rules as required to be included. But even within those documents, you can give a brief outline of your case in a persuasive way. Now, I generally find that a chronological order works well in terms of giving the narrative of your case. But sometimes it might be better to put it in terms of themes, but you should include within those statements a brief outline of your case that's presenting it well to the tribunal. So right from the get-go, they understand what the main issues are and they understand where you're coming from. Now, turning to the statement of case and the defence, what are the sort of key things that you need to do there? Again, look at what the elements are stated in the rules, but then they don't really tell you very much. But in terms of how I like to go about it, I like to initially have an introduction, explains who the parties are, what the dispute is about, again in a brief and succinct way. Then I move on to something which you might call background to the disputes, you might call statement of facts, depending upon your style, obviously, where again you recite in a narrative form your side of the story. You're putting your side of the story to the tribunal. Now, it's important in that respect to only include what's relevant. You don't want to include a whole lot of irrelevant facts and events, but you need to include everything that's necessary for them to be able to understand what's happened and why you're bringing this claim. Frame it. So frame it in the best possible light for your client, but don't use emotive language. I always think a sort of dispassionate style works quite well. And I know we're going to discuss this more, but cover off the things which don't look as good for your client, because now is your chance to actually present the way you see it. So that includes the stuff which maybe you don't think is as nice a part of the story. Better to get it up front than have it come out later. Obviously, it has to include all the key dates, all the key people, all the key events. And then it's very important in the next section that you set out what the legal issues are in the case. You might want to have an introduction at the beginning as to these are what the legal issues are, or have put that in the introduction right at the start of the document. But go through each issue in turn. And here it's very important to have a structure to address those legal issues in a logical way rather than in a sort of ad hoc way. Use headings. I think headings and subheadings are very, very helpful. State clearly what the claim is, what the legal basis for it, and what the support is. Set out what the cases are. That's something that sometimes counsel in this region forget, is that in arbitration, you're supposed to actually cover what the law is in these documents. So set out what the legal grounds are to support each element of your case, and make sure you go through each element that's necessary to establish the claims that you're making. And then obviously you need a section at the end which covers the relief. And this should be, again, very clearly drafted, but also make sure you have a bit of a catch-all for any other orders that the tribunal might want to make. And consider things like interest and costs, and make sure you include those in terms of your claims for relief. So that's just a brief outline as to the approach I take to a written brief.
Thank you very much, Amanda.
Oh, I should mention you've got to attach everything. I forgot to say that. You need to attach the factual exhibits. You need to attach the legal exhibits. Follow what the procedural order says about how those should be numbered. Again, do it in a logical fashion such that you can add on to them as the matter goes along. So I normally just follow C1, R1 for respondent, CL1 for legal exhibit, RL1 for respondents' legal exhibits, and then can add on to them as you go through the matter.
Yeah, thank you very much, Amanda. Very useful in selecting to give like the big picture for the written submission. Just one follow-up point about legal submission. Normally, what in your practice, like how to like attach all the legal, for example, in our civil country, we have like some section, and also we have Supreme Court precedent. What do you think about it? We need to like submit or attach all those like section and including translation and present of the court case, including that.
Yes. I mean, you are supposed to set out the legal grounds and provide support for them. So yes, I think you should attach the legal cases that support what you said. Again, it's a balancing act. Obviously, you don't need to attach all the cases over the last 100 years. You select the most recent, the most authoritative. And yes, translations are very important. If the arbitration is in English and exhibits and legal authorities are in a different language, then yes, get them translated. Sometimes if time's very short, you can follow up with the translations, but the best course is, of course, to file them at the time.
Thank you. So for the next question, may I ask Kun Pisut, are there any particular tips or techniques which you would employ in drafting post-hearing brief?
Thank you, Kun Warathorn. When we talk about drafting post-hearing brief, I wish to focus on the main purpose of the post-hearing brief. At that juncture of the arbitral proceedings, the party have already submitted their written brief, pre-hearing brief. The party have already presented their witness. The party have already passed the cross-examination of witness. And during the hearing of witness, during the cross-examinations, you might have cross-examined so many points against the opponent witness. And some of the points may not lead to conclusion by itself. So the main purpose of the post-hearing brief for me is to wrap up what you try to persuade the tribunal during the cross-examination, and you try to link the key point in your cross-examination, link it to your submissions, and link your submission to the particular evidence present during the trial. A few tips is that you may need to ensure that whatever you have made as submissions in the post-hearing brief must lead the tribunal to some conclusion, and you have to ensure that that conclusions is brought in a logical way. You have to convince rather than to confuse the tribunal. So a logical drawing of conclusion is necessary. And you need to structure your submission in logical and make it easy for the tribunal to follow your thought, and avoid contradicting ideas in your submissions. Because I have seen in many cases, I have seen the opponent party make a post-hearing submissions, and in the same submissions, they put contradicting ideas, and that should be avoided. What you may need to highlight in your submissions is to try to point out to the tribunal on the inconsistency or unconvincing or irrational fact or irrational submissions presented by the witness of the opponent party. And the next tips is that there might be a lot of issues, there might be a lot of arguments raised by the parties during the hearings, and you don't need to attack all of them. In the post-hearing brief, you need to consider what would be key important issues that would lead the tribunal to make an award in your favor, and focus and highlight on those key important issues rather than touching all of them, because you have already done so in your hearing submissions already in a more comprehensive way. So in my style, the post-hearing brief will be more focused on key issues. And the last tips that I always use in drafting the closing submissions or post-hearing brief is that I will use plain language, because I believe that plain and simple language is the best way to communicate your writing, your idea in the form of writing more effectively to the tribunal. You need the tribunal to understand quickly as possible when he or she read through your submission in one go, rather than asking them to reread again and again before they get what you need to present. Yeah, that should be a few tips.
Thank you, Kun Pisut. Since Kun Pisut make a very good point and interesting point on not confusing the tribunal like for post-hearing brief. So in this issue may lead to another question to maybe Sapna to respond on this, like, is brevity necessarily good to use like for the submission on in writing? And also maybe another point, normally we are often told not to be like hyperphobic and over emotive language. What do you think on this issue as well, Sapna?
Thank you so much, Warathorn. Okay, so to answer the question, is brevity necessarily good? I think there's 2 points that you need to separate out. So firstly, you're going to have to set out the facts, evidence and law that you want to rely upon in sufficient detail to prove or disprove whatever is important for your client's case. So don't skimp on depth of detail for these crucial facts. Make sure you stick in what's relevant and you go into sufficient detail. Where I think brevity is necessarily good is avoiding extra words when they are otiose to what you wish to say or they're repetitive. So for me, cutting out extra words and repetition is always a good thing, whether in written advocacy or oral advocacy. My rule of thumb is not to offend, tire or distract the mind that you're trying to persuade, and I think that extra words and repetition are very, very distracting. And I'll give you one example. About a month ago, I was preparing for a hearing with a junior that I had not worked with before, and we were preparing the opening submissions for the first day, and I asked her to insert all the references in from the hearing bundle. So she inserted all the page numbers from the hearing bundle and the footnotes, and every single reference said page X of the hearing bundle, page X of the hearing bundle. So I looked through the footnotes and I saw the words of the hearing bundle peppered everywhere. And I just said, those are extra words, we just don't need them. All we need to say at the beginning is any references to page numbers are 2 pages in the hearing bundle. And it sounds like a very subtle point, and it sounds like I'm very dogmatic, and maybe I am, but those are extra words that we just don't need. I don't want even one extra word in my written advocacy that's not meant to be there. I want every word, every sentence to make an impact. I want clear, crisp, sharp advocacy. And I think it really comes down to what Kun Pisut was talking about, which is you really want your written advocacy to be easily digestible to the tribunal. And to me, skipping out extra words is key to that. I think it also includes not using archaisms that we have in English, such as here and after. I mean, why not just say below? People don't speak like that. And again, to me, you're putting up a barrier between making your advocacy easily digestible. You're making people think more because those are not words that are in common usage. something that's very common in Singapore is using the phrase the same. And I'll give you an example, something like, I picked up that document and then I put forward the same. And when I read that, and it happens all the time in legal submissions in Singapore, when I read that, I always have to think for a minute and think, what is the same? What is it actually referring to? And again, that is a layer of thought that I do not want a tribunal reading my written advocacy to have to go through. I want them to know immediately what I mean to say. I want the meaning to scream out of the page. I don't want them to have to pause for a minute. And I want their thinking focus to be on digesting the points and considering whether they're compelling or not, and not trying to seek clarity or meaning out of them. So I think this leads on to your question about hyperbolic language. And one of my mentors at the English bar, who's a very senior now QC, says to me, never use an adverb unless it forms part of the cause of action. So for example, if your cause of action is only made out if something is done maliciously, then by all means say X did this maliciously, because you have to have that as part of the cause and action. But in his view, a denial gains nothing by being made vehemently or categorically or expressly or specifically. And he also hates words such as blatant, brazen, spurious, and purported. Now, I'm not as dogmatic as he is. I've used the odd adverb brazenly. I've said egregiously from time to time. But I do think that you need to use these verbs judiciously and sparingly. And I think it all comes down to credibility. If you use words like that peppered throughout your written advocacy, all you're doing to the reader is essentially making them immune to all of that type of language, all of that dramatic and hyperbolic language. And they're basically reading your advocacy and filtering it all out. And it has no impact whatsoever. And what it means is that when you do want to use emphasis to highlight something that perhaps was particularly egregious or brazen, you've lost all the impact of that emphasis. So I am not dogmatic about completely avoiding overdramatic or hyperbolic language, but I think that use it judiciously. I think the style that Amanda advocated of fairly dispassionate, objective language, you can see why that kind of factual style would actually be very credible when you're describing matters. So I think that's a good thing to aim for, but use emphasis where you need to. You know, one good practice, I think, in aiming for the crisp style of advocacy that I'm advocating for is to leave a little bit of time between your first draft and coming back to editing it, because I think it's only when you have a little bit of time to digest and get some distance from your first draft of advocacy that you can go back and seek to edit it down into its most succinct form.
Thank you. Thank you, Sapna. Really useful. Next one, sometime when we preparing the submission, actually for written submission, we have like some weakness. So maybe we how to like effectively deal with the weaknesses in your case. To what extent should we PM your opponent argument and address them in our submission? So this question maybe ask Luan, and maybe Edmund can add anything. Go first with that Luan piece.
Thank you, Warathorn, and good evening, Los Angeles time, and I think good afternoon in Singapore. I want to start with the importance of preparation and the importance of focusing on the weaknesses of your case before I get to the submission, because like everything else in the matter, preparation, I think, is of utmost importance. Most lawyers make the mistake of falling in love with the case. What I mean by that is most lawyers, they spend a lot of time focusing on the good stuff in their case, right? How to prove their case, obviously. And they get into and they talk with their colleagues who work on the same case, and they have that silo mentality where they just focus on the good stuff. In America, we have the expression that you need also to embrace the ugly, right? I think personally, you should spend as much time on the ugly parts of your case, the bad facts, the bad laws, as you do on the parts that are already solid in your case, right? And I think that's very, very important. And if you were to wait until the submission time to start focusing on the weakness of your case, I think you're really already behind the 8 ball, right? So, so one of the ways for me to prepare to deal with the weakness of my case is actually, and to avoid a silo effect, is actually to test drive my responses or explanations for my bad cases or for my bad facts with people outside of my law firm. Either my colleagues, my friends, or even I'll pay someone to run those explanations. And I'll give you another example. In the US, as you may know, we have the jury trial system where you basically have to try very complex cases before lay people who are not necessarily the most educated people, right? And I think Sapna and Pisut rightly said earlier about the importance of being simple, right? Keep things simple, right? Don't use big words. And when you have to deal with the jury, you actually have to do it even more. So my point is, in our practice, especially litigation practice, we actually sometimes do mock jury, where we test out not only our good part of the case, but the explanation of the bad parts of our case. And sometimes I found it very helpful. If we have an international arbitration panel, we would sometimes hire attorneys who have similar background as the arbitrator to try out these different theories. And you'll be surprised how people look at your case completely different than you and your teammates, right? So that, for me, it's very important. The preparation, I think, is very important. And when you get to the submission, obviously, if you were to go first on the submission, my preference always is to preempt the weaknesses of your case. And hopefully by that time, you have a good grasp of what explanation makes sense, right? And because I think that we all know that the ugly facts would be raised by your adversary, right? And if you not raise them, when you have first chance to do so, your opponent's not only gonna note the bad facts, but they also note the fact that you failed to tell the tribunal about the bad facts, right? So I think that you have to be mindful of that. However, there's one exception that I think you may want to consider. That is, in a situation where you have the last word, you have the right to a reply brief, right? And sometimes, some cases, it might make sense that you barely mention the bad facts. You let the other side, make the arguments, and then you have a chance to have the last word on, how to address the weakness. So generally speaking, I don't like to do that, but sometimes it might work, depending on the facts of the case. So so those are the point I want to share right now, but I'll leave it up to Edmund to follow up.
Thanks, Luan. I'm just going to be quite brief. I only have 2 points. They sound a little bit contradictory, but in reality, they're not. The 2 points are these. Deal with the weaknesses in your case because you can control the narrative. And the second point is, don't do your opponent's job for them. Let me explain. They sound a little bit contradictory, but let me explain each. The first one, every case is not, there's no perfect case. There's always going to be some issues with your case. And if there are obvious issues, you probably want to deal with them at the outset in the best way possible while being honest about things. You can't be untruthful. You shouldn't lie. You have to deal with the facts head on, but you control how you tell the story surrounding those facts. And a classic example of this is a lot of people don't realize that Singapore lost a major international arbitration against Malaysia involving the railway land. The Malaysian railway land that used to come right into Singapore, that Singapore bought back from Malaysia. Singapore lost. And many of you will be thinking, well, I never heard about this case. but this case was on the front page of the news. And the reason why you might not remember it, or you might not remember it as a loss, was because Singapore said this was a triumph for arbitration. It was a triumph for arbitration. Singapore somewhat changed the narrative from we lost in a case against Malaysia to this is a triumph for arbitration. Same facts, different narrative. So just remember that story. The second point is you may get to see a lot of issues with your case that the other side hasn't gotten to see. If there are issues that are obvious, you should deal with them. If there are issues that maybe aren't so obvious, maybe you see these issues because you're perhaps a better lawyer than the other side, or you're a bit paranoid about your case, don't do the other side's job for them by bringing up all these problems. And sir, there are 27 issues with my case, and I'll deal with each of them right now. Because the other side may not have seen all these issues. And don't articulate these issues with such clarity that you do a better job than the other side in articulating these issues. So you have to ask yourself, are these obvious weaknesses that I can deal with by changing the narrative, if appropriate? Or should I leave these alone? And let's see if the other side even brings them up. It's a balancing exercise. Thank you.
Yeah.
If I can just add to that, I think
sure.
there's a distinction between factual weaknesses, which you know are pretty much going to come up. And I had a recent example of this where I was sitting as tribunal, where there was a very important email which had been sent from one side to the other and had not been mentioned in the claimant's witness statement. Now, and that was, I think, partly because they thought the other side didn't have counsel and so it wouldn't come up. Then the other side got counsel right before the hearing. And so it came up and they had to address it in reply. And then it was very embarrassing. You know, they weren't able to control the narrative around it. And it looked weird that it hadn't been mentioned before. So, you know, certainly factual weaknesses, I think you really do have to address from the beginning and assume that they will be revealed, particularly if it's correspondence going from one side to the other. Legal weaknesses, I totally agree with Edmund, don't make the other side's case for them. So you've got to think, is this so obvious, such an obvious weakness that I should address it up front, straight away? And sometimes you can tell from that because I might have referred to it in the response to the notice, for instance. So you already know they're going to raise it. So then again, you might want to control the narrative. Or is this something that I can wait and address later? And I totally agree with Edmund, don't put their case in a better way than they do. And sometimes that's a real challenge when you get back pleadings, which are very unstructured, have points in them, and you're thinking, well, how do I respond to these points without actually expressing them better than they have? That is a real art as to how you do that, because you don't want to actually structure and make their points clearer than they did. So it can be quite tricky.
Can I just add in as well? I think all these points, what they really go to is one part of advocacy that we've touched on but not really addressed head on, which is there is a lot of strategy involved. So I said, you know, set out your case in sufficient detail so that you can prove it, but you also need to be very mindful, just as my fellow panelists have said. So for example, as Luan said, if you may not want to raise a point in your pleading if you know you're going to get a right of reply, and you don't want to, as Amanda and Edmund said, put it better than the other side. You want to see how they put it before you reply to it. And I think there is strategy involved. That would also go to, for example, your statement of case. You are under the SIAC rules supposed to put in your submissions of law. I will often put in, if I'm a claimant, and I usually am a claimant, I would actually, I'm usually very brief on the law. I let the other side raise any defensive issues of law, and then I will often reply, and I would do actually save a lot for the hearing, and that's part of strategy. So I try obviously comply with the rules, but I'm not setting out my full case on the law with all my cases and my statement of claim. I don't do that. But so there is strategy involved, and that's something that you that all our attendees and participants will learn with experience.
Yep, thank you very much. So since this topic, like everyone almost share, so any comment from Kun Pisut to compete from your view?
Everyone speak very well, and I don't have any room for making any additional.
Okay.
And I don't think we have enough time to.
Thank you for the next question. For Edmund, would your written advocacy style differ depending on your tribunal, whether civil and common law? You have a different effort or not?
Yes, thank you. I think the answer is it should depend, your writing style should depend on your tribunal. You're always writing for the tribunal. There are some stereotypes which are quite valid as between common law tribunals and civil law tribunals. For example, common law tribunals might be better persuaded using certain language or a certain sequence of the arguments. Civil law tribunals really depends where they come from. There are some civil law tribunals that believe in this Latin maxim, jura novit curia, which is basically the tribunal knows the law, the judge knows the law. So if you go heavy on the law, they might be thinking, well, you're telling me what my job is. I should know what this is all about. Give me the facts. So you really need to assess who you're appearing before, what they've done in the past. So ask people, let me be quite blunt about this. If I'm appearing before Amanda, or what's Amanda like? What does she like? You've been listening to her, so you know what she likes. And that's excellent intelligence for you in terms of how to structure that submission. Thank you.
Yeah. So Amanda, you have anything to add on this?
I agree with Edmund, but I think at the core, there isn't actually that much difference depending upon whether or not the tribunal is civil or common law. I think that the core skills that you need to demonstrate in a written brief in particular, it's a little bit different when it comes to the oral side, but in the written brief, I think the core are the same, which is really demonstrating logical and clear thinking and showing a narrative.
Yeah, thank you. Since we have limited time, so we will move on the oral advocacy. For the first question, what are the key mistakes made by the counsel with like strong litigation background but with limited experience in arbitration? Sapna, you want to share something? Yeah.
I think it's the same point, really. It follows on from what Edmund says, which is you should flex your style according to your tribunal. There are, of course, key differences between litigation and arbitration. If I can just mention three, courts usually have inherent jurisdiction over the claims before them, but in arbitration it's consensual. Secondly, courts tend to have rigid procedural rules, whereas in arbitration there's lots of flexibility. And lastly, certainly in the common law context, when it comes to witnesses, you often have rules of evidence which require you really to put to witnesses every point that you challenge them on. Whereas in arbitration, and this is a sweeping generalization, but there does tend to be less emphasis on witness evidence. I do think arbitrators prefer to make their key findings on documents. So if you bear in mind those key differences, if you've done a lot of litigation, you come to arbitration, I think you do have to flex your style. If you're going to be really, really aggressive, if you bear in mind that arbitration is consensual, what arbitrators really like is cooperation between counsel, basically making the tribunal's life easier. They'll really appreciate that. So don't be overly aggressive, criticize your opponent's arguments, do not criticize your opponents, that will not go down well. Secondly, flex your style with witnesses. I think your cross-examination has got to be a lot more focused. You don't need to, I've seen examples where litigation lawyers have said, oh, we need that witness in the witness box for 3 days, and I've said, actually, I think you mean 2 hours. Really, there's a huge difference in terms of scope and necessity for cross-examination. And even in cross-examination, you may get away with being very aggressive towards your witnesses, but I suspect that before many arbitrators that will go down less well than it might in common law litigation. And I think the last point really is just to be fairly open-minded, particularly when it comes to procedures. Because it's a consensual process arbitration and because the procedures are very flexible, the tribunal is going to want buy-in from the parties over the procedures that are determined for the arbitration that are proposed. So I think be flexible, be cooperative, don't be dogmatic when you're approaching various procedures or proposing them. I think having that ability to adapt and be flexible will go a long way.
Thank you, Sapna. For the next question for oral advocacy, Luan, what is your one thing that a common law practitioner should look out for the term of making persuasive oral argument to the civil lawyer and vice versa? What would you like adapt your advocacy style depending on whether your tribunal is civil and common law trained by the oral advocacy? What do you think?
I think at the outset, I think you should be mindful about the difference in between the training and practice of a common law lawyer and a civil law lawyer. But obviously, we're talking generalization here, right? Stereotypical here. For example, common law system is very adversarial, mostly adversarial, right? At least compared to the civil system. What I mean by that is most of the time, the lawyers, they do fact findings. They ask questions at trial of the witnesses. They do conduct cross-examination of the witness, very intense cross-examinations, and also the importance of precedent and stare decisis in the resolution of the claim, right? In the civil law system, we have more of a inquisitional approach where the judges do fact findings, ask questions. You know, the lawyers have very limited right of asking questions, sometimes in certain jurisdiction. I think the lawyers, if he or she wants to ask question at trial, would have to submit the question for the judge to ask those questions. And obviously under the civil law system, there's a very importance of the applicable code and statute as opposed to court decision precedents, right? I say these are very generalization because when you deal with arbitrators who are very sophisticated and experienced, it really doesn't make, I think, not much of a difference because he or she would have gone so many cases where, you know, presiding over matters, different jurisdictions. So it comes down to the basic of, you know, what you need to do to prevail in oral advocacy, right? So that is less. But I think that this is similar to the question on litigation, you know, and arbitration, whether you have to change your oral advocacy style. I can tell you from my personal experience having litigated in U.S. court, you know, as you can see in the movies or, you know, in your real personal experience, I mean, there's an element of theater, you know, in U.S. trials, right? And a lot of U.S. trial lawyers, very experienced ones, they make a mistake when they try the first few international arbitration where the aggressive style would not go well, sit well with the arbitrators, right? And also where, you know, you think that you crush the witness in cross-examination, like make that witness look terrible. It's a good thing, but turn out to be like you actually make the witness very sympathetic to the arbitrators, especially those from the civil law system where they're not used to having lawyers like questioning witnesses. So that they actually might get offended by that, right? So I think that, yeah, your style has to adjust somewhat when you depend on your audience. So that's something that you have to keep in mind. But at the end of the day, I read something really interesting when I was preparing for this. This is some quote from Cicero, the Roman senator, you know, but famous Roman senator, known for his advocacy art, right? He said that the rules of oral advocacy is like this. First, be clear so the audience can understand what is being said. Be interesting so the audience would want to listen to what is being said, and be persuasive, so the audience will agree with what is being said. So I think it's come down to this, right? Regardless whether the audience is a civil law or common law practitioner, those are the cardinal rules that we all should remember. Thank you.
Precisely. Really, totally agree with you. The next one, from the tribunal perspective, what are the strengths and weaknesses of the counsel from common law background vs that of the civil law background? Maybe we go with like Edmund and also Kun Pisut to share experience and thought on this issue.
Thank you. I think one difference I see between common lawyers and civil lawyers appearing before me when I'm sitting as an arbitrator is that common lawyers generally, I say generally, are better at laying out the evidence, laying out the story through witness examination than civil lawyers. And I think it's a question of practice. It's not a question of innate intelligence or skill. It's a question of practice. I think the common lawyers are trained to get a witness to tell the story and are trained in examining a witness, let's say cross-examining a witness, to tell a different story in the way they want. Too many times I've had civil lawyers appearing before me saying it's all in the documents, asking one or two questions of the witness that don't really go anywhere. I'll get to this in the one cardinal sin section later. It's coming later. When they have a wonderful opportunity of getting this witness to say, well, I entered into this deal because this was supposed to happen and that was supposed to happen. And then what happened was he suddenly told me that, he didn't want to do this anymore. You might think, well, I can resolve everything on the face of the documents, but in reality, a tribunal, we're supposed to be human beings. We are human beings, right? We're going to, that's the difference between making submissions to a computer and to a human being. We do have some human characteristics that you can rely upon in trying to persuade us. And that witness telling the story through your questions is something that's very, very useful. It doesn't come out so much from civil lawyers. And I wish that could be addressed. Thank you.
Yeah, thank you, Edmund. I could not agree more with your analysis and totally agree that part of it is the different practice between common law practitioner and civil law practitioner. And apart from that issue, I also see that the weakness of civil law practitioners may come from language barrier as well. My understanding is that common law practitioners, if not all, most of them have been practicing advocating skill using English as the language for advocacy, whereas many of common law practitioners have been practice using English as their first language in advocating skill. So that may be additional point to make as an observation on a weakness of civil law practitioner in international arbitration.
Yes, agree. I also face some difficulty because we are not native in English, like Kun Pisut mentioned when I first do the arbitration thing. So we have a little bit time to discuss a little bit on a virtual hearing. Hope you how would you modify or adapt your advocacy style for the virtual hearing? Maybe Edmund can share this issue of start within 1 or 2 minutes, and Amanda, any thought on that?
Yeah, I'll be really brief. I think the first thing is you have to slow down in terms of how fast you're speaking. You have to speak more clearly because your words are being transmitted through Zoom or whatever other platform you're using. You have to ensure at the right time that you are looking at the camera as opposed to looking at a person. And this is it's a bit of a trick to ensure that you're looking, or you look as if you're looking at the person when you're not really looking at the person. So in effect, you're going to have to be the CNN news anchor. And if you come across like one of those guys, Chris Cuomo or somebody else, with great lighting, great sound, and they say that sound is more important than the picture. Sound is more persuasive than the picture. Great sound is something that you should really try to achieve. Great sound, great picture, great overall impression. I think you're going to be effective in virtual hearings. You're going to be limited in terms of your body language. You'll be limited to tilts of the head. Nobody's going to be able to see your hands. So if you're the kind of person that is used to standing up in front of a court, or at least being physically present and using your hands to persuade, you might be hampered in that form of advocacy. So just bear that in mind. Thank you.
Thank you. Amanda, anything to add on this?
Yes, thanks, Edmund. I've done 2 virtual hearings as the arbitrator. And the comments, I totally agree with what Edmund says. And for someone like me who loves to use their hands, I find this little box thing quite limiting. But in terms of arbitrator, the things I observed are, one, even more than normal, you have to be prepared, because pauses, long pauses while you're shuffling around for documents, look terrible on video. When you're in real life in the room, you can see that someone's just looking for their document in their bundle. But on the screen, you don't know what they're doing, and you're thinking, what's going on? Why are they not getting on with it? And at occasions I had to say, oh, should we have a little short adjournment? Or, so be prepared. Make sure you're very clear about references to the documents, and make sure that you give the chance for the tribunal and the witness to get to the same document, because again, they're not able to pick up on any visual clues as to what you're looking at. And in terms of questioning of witnesses, it is imperative to use short questions, questions which you answer yes or no primarily. You cannot give long questions in which you say, well, on the assumption that blah, 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 do it like a whole paragraph. Yeah, what's your response to that? The witness has no chance in a virtual setting. Even more so in one of my cases where we had translator as well. So you really need to have, which I think generally is best in any event, in physical hearings as well, but even more so in virtual hearings, short questions when you're doing cross-examination.
Sorry, could I very, very quickly just add on to a point? The text setup is very important. The text setup for the arbitrator, the text setup for the witness. It's very hard to exert psychological control over a witness when he's staring at you on his mobile phone and your face is the size of his fingernail. Yeah. So if you can at all, ensure the witness has a large screen, and you can do this under the pretext of, well, he needs to see documents, so he's not going to be able to do it on his small mobile phone. Get him a large screen so he can see you right up in his face, and get the tribunal, or ensure that the tribunal has large screens as well for the same purpose. You need to be persuasive. Yeah.
And as Edmund said, the hearing and sound, I mean, this is why I use these headsets, because I find them best. But make sure you check and test all of that well and truly beforehand.
Can I just add one point? From the hearing I had around a month ago, which was virtual, we did it on Zoom, and you get providers who will manage the whole process for you and do the tech checks, the audio visual checks every time everybody's logged on, which is quite useful. But I thought the screen share option of being able to screen share the relevant document from the hearing bundle was actually a benefit of virtual hearings. And I mention that because I think it's better than having everybody look at hard copy documents and wait for the tribunal to leaf through and find the relevant page number. If you can screen share, and I didn't do this myself, I got my junior to do it. I just read out the page number. If you can screen share, then nobody has to faff around looking for documents. It's right there. And I thought it was actually very powerful to cross-examine witnesses with them having the document right in front of them and everybody looking at the same screen. I actually found it to be hugely beneficial, except I would completely agree with Amanda that I had to abandon all the long questions, which were probably too long even to ask in person, but it really is very difficult in a virtual setting to ask long questions. You just lose the momentum completely.
Can I say though, on the document sharing, I think electronic documents are the way to go, but I think even better is to actually have a separate proper electronic document service set up, which is on a separate laptop, which everyone has access to. Because the problem as the tribunal is with the screen sharing is that the face of the witness then becomes very, very small on your screen. So actually picking up their body language becomes quite difficult, even with quite a big screen once the documents have been shared. And also those electronic document providers such as Opus and Epic, there's a lot of other things you can do, like show documents side by side, pull out highlights and etc. So I agree electronic documents is the way to go, but I think it's worth investing, using some of the money you're saving from the travel to invest in a proper electronic bundle.
I agree on that. We come to the last question for every panelist. The last question would be from a tribunal perspective. What is the one cardinal sin that counsel commit which annoys you the most? This question maybe 30 minutes, 30 seconds for each of the panelists. Maybe go with Luan. Luan first. Yep.
This has to do with cross-examination. A lot of lawyers, they don't know when to stop after they got a good answer. For example, if you just got a lot of them got a good answer on admission from a witness, the lawyer would go on and say, so what you're telling me is this, and then you give a witness a chance to just correct or explain it away, and you lose the effect.
Thank you. For next one, maybe Kun Pisut.
Yeah, for me, as a counsel, you are acting professionally. You have to act professionally. Don't argue with the witness, even if the answer of the witness is not in your favor. Because when you argue with the witness, the tribunal may not see you in a good way. Give the witness with respect and you will get respect from the tribunal.
Good, thank you. Sapna, anything that you would like to mention?
Reading out written submissions. I'm amazed at the number of times I've seen it where someone has filed a written opening and then for their oral opening, they just read it out. I'm shocked. Everybody can read.
Okay, then Edmund.
Yeah, thanks. Don't ask useless questions like, read this document. Right, what does this document say? I can read it as well. Don't ask useless questions. The questions have to be useful to whatever you're doing and useful to the tribunal. So if you're going to do that, look at this document, then ask the question about the document. Don't ask the witness to tell you what the document says. We can all tell.
Thank you. The last one go with Amanda. Yeah.
Don't copy the tribunal into intemperate correspondence between the parties. So don't have, and I'll give you another example. In a recent arbitration in which I was sitting as arbitrator, one party had asked for a very short extension. I gave them an extension, I think it was about 2 days. I then, bizarrely, after the extension time had already passed and they'd actually responded to the particular issue, got a nearly 1-page diatribe as to why I shouldn't have given them the extension and as to, all the things they were doing wrong. Well, that just irritated the hell out of me. So, be very careful about writing long diatribes about why or why not in terms of procedural issues. Parties have done certain things, and don't copy the correspondence into that. The correspondence between parties, don't copy the tribunal into that either. It really doesn't come off well.
Thank you. Thank you very much. So I think we have only like one minute left for the four. If they have any question, so for the four, do you have any question to may ask like the panelists on this? Anyone? So I think if I not seen any question, but for my personal question, because I came from like the civil law country and also not like native in English. So what your opinion or recommendation for like the lawyer from civil law background, not the native in English, for to like participate in arbitration? Any specific tip for those come from civil law country and not like English native? Anyone want to finish and give like recommendation to this?
Learn how to cross-examine.
Yeah, good. Thank you. Anyone?
I think see if you can hook up with experienced counsel and shadow and learn that way. I think that's a very, very good way to learn. So either as co-counsel or get the opportunity perhaps to be a tribunal secretary, so that you get exposure and learn about the process. But do get involved. There's some great civil lawyer counsel in arbitration. You know, there's some fantastic people, so don't feel afraid about getting involved.
Thank you very much. Our time is really limited, and we come to the end of the session. So I would like to thank you all the panelists and also the participants for a very fruitful and useful session. So thank you everyone. Thank you very much.
Thank you.
Thank you. Thank you.
Thank you.